Here.
Here.
Very good. All right, we'll have a pledge of allegiance, and let's see, I'll ask Commissioner Berger to lead us, please. He always does such a nice job.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you, sir. All right, per usual, we have a few reminders of our housekeeping announcements. These kind folks at the First District Court of Appeal let us use their facilities, so we have promised to treat them very gingerly. So please respect their rules. We ask that there be absolutely no food or beverage other than water in this room. We also ask that you silence your cell phones, and that when anyone is addressing the commission, that you do so from the podium and that you speak up into the recording equipment so that we can pick you up properly. And also, as you know, we have a little bit of a distinction between the microphones that work for the session in here versus the microphones that work for our public streaming of the meeting. So please speak up and speak into the microphones, because we regularly get let's not call them complaints, let's just call them observations that the sound isn't great on our streaming. So I want to try to do that. And if you desire to be heard in a matter, Ms. Fulford is here today, right? She's, oh, you have moved into a different location. I missed you there, Millie. Thank you. So she'll take care of you if you're going to be a speaker today. Okay, next item on our agenda is the approval of the minutes. Do I have a motion? We have a motion from Commissioner Rosenka, a second from Commissioner Dr. Brady. Any discussion? Seeing none, all in favor, please say aye. Aye. Opposed, nay. Motion carries. Minutes are approved. All right, our first item for consideration today is case number 2017-13, N. Ray Nancy Oakley. We take appearances, please.
Melody Hadley, Commission Advocate.
All right, is anyone here on behalf of the respondent? Thank you. Okay, so we have, and the complainant will not attend. All right, Ms. Hadley, this is a consideration of the recommended order of the administrative law judge for the Division of Administrative Hearings in complaint number 2017-13, N. Ray Nancy Oakley. The administrative law judge order recommends that Ms. Oakley be found in violation of section 112.313, subparagraph 6 of the Florida statutes, and recommends a public censure and reprimand and civil penalty of $5,000. The respondent did not file exceptions with the commission, but did untimely file exceptions with the Division of Administrative Hearings. The advocate moved to strike the exceptions, and in the alternative has also responded to the exceptions. So, members, if we grant the motion to strike, we presumably do not have any need to hear argument on the exceptions, but it is our proud history here at the Commission on Ethics that we tend to look to the merits of matters and issues before us. So unless there is an objection, the chair's recommendation to the commission would be that we go straight to the exceptions and allow argument from counsel. Any motion with regard to the motion to strike?
Second. For the chair's recommendation. Is that what your motion was?
Well, thank you. Okay, so we'll proceed.
Just to clarify.
I don't think we need a motion on the chair, so we'll proceed. Ms. Hadley, please proceed.
In this case, respondent violated section 112.3136, which is the misuse statute. The administrative law judge found that there was clear and convincing evidence that proved that respondent misused her position by exhibiting inappropriate behavior towards city staff. And on December 7th, issued an order recommending a fine of $5,000 plus public censure and reprimand. I stand by my written arguments regarding respondent's exceptions, and I ask that you deny those exceptions. The administrative law judge's legal conclusions are supported by logical, reasoned consideration of facts and pertinent law. His findings and conclusions should not be disturbed. I ask that you enter that recommended order as your final order. Thank you.
Any questions for Ms. Hadley? All right, seeing none, Commissioners, I would remind you that under the Administrative Procedures Act, we are unable to reject or modify findings of fact unless we determine that there is no competent substantial evidence to support the finding or that the proceedings on which the findings were based did not comply with the essential requirements of law. In other words, we have a high standard. If we reject or modify a conclusion of law, we must find that our substituted conclusion of law is as reasonable or more reasonable than the judge's. So is there any motion with respect to the advocate's recommendation concerning the exceptions before us? Commissioner Berg.
Motion to approve the advocate's recommendation of the administrator.
And acceptance of the recommended order and entry of the final order. All right, is there a second?
Second.
Okay, we have a motion and a second and a flag from our chief counsel to the chair. Yes, sir.
Thank you, Mr. Chair. I believe, Mr. Schaefer, you wanted to make a statement about the overall situation in regard to your draft final order.
Yes, thanks, Chris. I just want to clarify, the motion here is to adopt the recommended order as expressed in the draft order presented to you all, which denies the exceptions, but take out then the portion of the draft order addressing the motion to strike.
Yes, that's correct.
Yes. All right, that's our motion, and it has been seconded. Is there any discussion? Seeing none, all in favor, please say aye. Aye. Any opposed, nay. Motion carries. The next item on our agenda that we will call is case number 2017-123, N. Ray Darrell O'Neill. It is before us for final action. Will the parties or counsel please identify themselves for the record?
Elizabeth Miller, advocate for the commission.
Thank you.
Andrew Salzman, an attorney for the respondent, Darrell O'Neill.
Welcome, Mr. Salzman. Glad to have you here, sir. Thank you for coming. This case was heard at the Division of Administrative Hearings, and the administrative law judge recommended Mr. O'Neill be found in violation of Section 112.313, subparagraph 6 of the Florida statutes and receive a civil penalty of $2,000 as well as restitution in the amount of $2,320. The advocate timely filed an exception seeking public censure and reprimand. In addition to the other penalties, the respondent filed no exceptions and did not respond to the advocate's exception. After the meeting materials were mailed out, the advocate and the respondent arrived at a stipulation, which we have just handed out to everyone, and it was emailed to you on January 16. You have the hard copies. In the stipulation, the advocate withdraws her request for public censure and reprimand, and the respondent accepts the finding of the administrative, the finding of the administrative law judge, including the finding that he violated the law, and agrees to the civil penalties recommended by the administrative law judge. The complainants have the right to comment in writing on proposed stipulations. We've not received any written information from the complainant. So as with all stipulations, the board, the commission may approve it or reject it, but we cannot modify the stipulation. If we reject the stipulation, we will go directly to consideration of the administrative law judge's recommended order and the exception thereto. So, in light of the fact that the case has been heard at DOA and the parties have stipulated as to the outcome, do you wish to hear from the parties, or do I have a motion?
I have a question.
That'll work too. Question from Commissioner Rosanka.
As I recall, the advocate recommends censure, but now you're not recommending censure, is that correct?
That's correct. In lieu of, or in return, the respondent will timely pay the civil penalty and the restitution and not seek further action, such as an appeal.
Is there a reason you no longer feel censure is appropriate?
It was what we agreed to get the money paid back to the city quickly and to not delay the case any further if there was going to be an appeal.
Any other questions for the advocate or counsel or a motion?
Motion to accept the stipulation.
Okay, Commissioner Carvajal has motioned to accept the proposed stipulation. It has been seconded by Commissioner Richter. Any discussion? Seeing none, all in favor, please say aye. Aye. Any opposed, nay?
Nay.
Motion carries. Stipulation is approved. Thank you, Mr. Salzman. Thank you. Thank you, counsel.
Thank you.
All right, moving right along, our third item of the day, consideration of the advocate's motion to dismiss, consideration of final action on the joint stipulation in complaint number 2018-26, In re Kim Daniels. We'll take appearances, please.
Melody Hadley, Commission Advocate.
Good morning, Ron Meyer for the respondent.
Welcome, Mr. Meyer. We have before us a proposed stipulation between the commission advocate and the respondent. The commission may vote to approve or reject the stipulation. This is not a pre-probable cause stipulation, so if the stipulation is rejected, the matter will be heard by the Division of Administrative Hearings, or the parties can attempt to arrive at a new stipulation. Complainants have the right to comment in writing on proposed stipulations. We have not received any comment from this complainant. So, Madam Advocate, please present the stipulation.
This is a case where a respondent, who currently serves as a member of the Florida House of Representatives, violated Article 2, Section 8 Florida Constitution and Section 112.3144 Florida statutes by filing inaccurate CE Form 6s for the years 2012, 2013, and 2014 respectively. We respectfully ask the Commission to enter a final order and public report consistent with this stipulation, finding that respondent violated the aforementioned laws, and refer the matter to the Speaker of the House for action consistent with Section 112.324, subparagraph 4, Florida statutes.
Thank you. Do we have any questions for our advocate? Commissioner Brady.
Any recommended penalties occur at the discretion of the Speaker of the House after receiving the order?
If there's a request, then there can be a recommendation when the person is a current member of the legislature.
Any other questions? Yes, sir.
I'd like to comment that I know the respondent in a professional capacity.
Okay. Any other questions for the advocate? We offer equal time to our respondent. Any questions for our respondent with respect to the stipulation? Any comment you wish to make as to the stipulation, Mr. Meyer?
Just that we ask the commission approve the stipulation as negotiated.
Thank you, sir. Do I have a motion?
Motion to approve the joint stipulation.
We'll take the motion from Commissioner Brady, seconded by Commissioner Rosanka. And we have a motion on the floor to approve the stipulation. Any discussion? Seeing none, all in favor, please say aye. Aye. Any opposed, nay? Motion carries. You may have your stipulation. Thank you, sir. All right, our next item, consideration of advocate's motion to dismiss complaint in Ray Michelle Timms, complaint number 2018-4. This is a case arising from the law which prescribes that the commission self-initiate complaints against persons who currently hold public office of employment and who fail to file disclosure and receive a $1,500 automatic fine. The purpose of the investigation is to determine whether the failure to file was willful, and the only available penalty is removal from office. In this particular case, information was received to indicate that the person was not required to file in the first place, and the advocate has recommended dismissal. Would any member like to hear from the advocate, or do we have a motion?
Motion to dismiss.
We have a motion to accept the recommendation of dismissal from Commissioner Carbajal, and it is seconded by Commissioner Richter. Any discussion? Seeing none, all in favor, please say aye. Aye. Any opposed, nay? The ayes have it. We now take up consideration of fees petition, final action on costs and fees. First case is N. Ray William Sturgeon, 2018, case number 9. The attorney fees case is filed by William Sturgeon, who is the respondent in complaint number 2018-9. Mr. Sturgeon's petition seeks to have the complainant, Christian Robertson, pay attorney's fees and costs following the dismissal of the complaint against Mr. Sturgeon. Staff has recommended that the petition be denied. At this stage, if the petition is denied, the case will be dismissed. But if the petition is not denied, the matter will be sent to the Division of Administrative Hearings. Are either Mr. Sturgeon or Mr. Robertson or their counsel present? Thank you, Ms. Fulford. We have copies of the file in this matter and of the staff's draft of an order dismissing Mr. Sturgeon's request for attorney's fees. Mr. Schaefer, will you summarize the staff recommendation on this petition?
Thank you, Chair. This case presents an issue all have seen before regarding whether a petition for fees and costs is facially sufficient to refer to a hearing at DOA. Just as a reminder, the fees and costs statute is found in the Code of Ethics in section 112.317, subsection 7. It's very specific about the circumstances in which fees petitions can be granted, and therefore it's also very specific about what has to be pled in order to be facially sufficient to refer to DOA. There have to be 3 elements established. First, that the underlying complaint contained false allegations. Second, that the false allegations concerned material facts, meaning facts material to the Code of Ethics. And third, the false allegations were made either knowingly or recklessly at the time the complaint was filed. This language is very strict, and case law tells us that attorney's fees statutes have to be strictly construed, meaning the requirements must be present and adequately pled for the petition to be considered facially sufficient. In fact, the rule about fees and costs says the elements must be set out with particularity in order for the petition to be referred to DOA. And because of the need to have those elements established, it follows that a respondent can't automatically have their petition sent to DOA just because they prevailed in having the complaint dismissed. In other words, just because you might find after an investigation that there is no probable cause of a violation and you might dismiss the complaint, that doesn't necessarily mean that the material allegations were false or recklessly alleged at the time the complaint was filed. That's the background. As the chair said, this particular complaint was brought against Mr. William Sturgeon, who's a city manager for the city of St. Cloud. It was filed by Mr. Christian Robertson. In his complaint, Mr. Robertson alleged several things, only 2 of which were found material to a violation of the Code of Ethics. So the complaint was only investigated on 2 grounds. These are the only grounds that really a fee award could be predicated upon. The first allegation was that Mr. Sturgeon used a city police car without authorization for personal reasons. And second, that when responding to questions from the media about the use of the police car, he authorized at least a portion of a press release that contained the city seal. These 2 allegations are investigated under section 112.313, subsection 6, to determine if they constituted a misuse of the respondent's official position. And after reviewing the ADREC and the ROI, you all found there was no probable cause of violation on either allegation, so you dismiss the complaint. But again, just because you found no probable cause, that doesn't necessarily mean fees have to be awarded. To recover fees, Mr. Sturgeon has to be able to show that the allegations were false, that Mr. Robertson, when he brought the complaint, knew they were false or acted with reckless disregard as to whether they were false. With the draft order before you, recommends you find those elements were not adequately pled in the petition. If you look at the petition, nowhere in it does Mr. Sturgeon specifically allege, with particularity, that Mr. Robertson knew when he brought the complaint that either of the two allegations were false or that he acted with reckless disregard as to their truth. Instead, the petition just makes the general allegation that the complaint contains false allegations, that Mr. Robertson knew or should have known they were false at the time he filed it. These general allegations are very conclusory. They just repeat the language in the statute, but they don't explain why the respondent feels Mr. Robertson knew the two allegations were false when he brought the complaint, or why he had reason to suspect them. So the petition just generally alleges that the complaint contains false allegations, provides no support, and then requests an order awarding fees and costs. Now, because the petition, in my opinion, is inadequately pled, I'm recommending that it be dismissed. I do want to note here, the petition asserts that Mr. Robertson brought the complaint against Mr. Sturgeon because he was upset that Mr. Sturgeon fired him from his job at the city, but that really doesn't move the needle on fees and costs. Even assuming that Mr. Robertson had that motivation to bring the complaint, it doesn't necessarily mean that the complaint contained false allegations, material to the code of ethics, and that Mr. Robertson knew they were false when he brought the complaint. So in short, I don't believe the elements of the fees and costs statute have been facially pled here, so I'm recommending you dismiss the petition. But if you have any questions, I'm happy to answer them.
Any questions for Mr. Schaefer? Quiet group today, okay. We have no appearance by a respondent or a complainant. No questions. Is there a motion on whether to dismiss and adopt the staff's draft order?
Motion to adopt the recommendation.
Okay, we have a motion from Commissioner Berger. Is there a second?
Second.
Second from Commissioner Rosanka. Any discussion on the motion? Seeing none, all in favor, please say aye. Aye. Any opposed, nay? Motion carries. Matter dismissed. We have next item 8 on our public agenda, consideration of advisory opinions. We only have 4 today, so we got that going for us. File number 2729 will be presented by Mr. Schaefer. Is the requester here? Go. Many no-shows today. All right, so the requester is not here. This is gift prohibitions, conflict of interest, district school board member affiliated with nonprofit that is accepting donations from or entering into contracts with digital vendors in Broward County, Florida. Mr. Schaefer, please proceed.
Thank you, Chair. Commissioners, this opinion does concern the gift law. The request is brought by a newly elected member of the Broward County School Board. And last year, before her election, she and her husband formed a 501c3 nonprofit called Make Our Schools Safe. Its goals are to raise awareness about school violence and to provide financial support for school safety initiatives. She serves as the president of that nonprofit. Her husband serves as the vice president, but neither of them take a salary or receive any consideration for Make Our Schools Safe, which is really the key fact to note here. Now, her inquiry hinges on fundraising. Make Our Schools Safe relies on extensive fundraising, and she's wondering if there'll be any conflicts for her if it accepts donations or contributions coming from vendors doing business with the district. As the opinion explains, this is an indirect gift question. The gift law, which is section 112.3148, that's going to prohibit a financial disclosure filer, like this school board member, from accepting a gift of over $100 from a lobbyist or principal lobbyist of their agency, or from a vendor doing business with their agency. And the statute's triggered regardless of whether or not the reporting individual accepts the gift directly from that prohibited source or accepts it indirectly. Now, the rules clarify the concept of an indirect gift. It defines it as a gift provided to a person or entity other than the reporting individual, when the benefit of the gift is received by the reporting individual and the donor intended for that benefit to be received by the reporting individual. The draft before you acknowledges this board member is very closely tied to Make Our Schools Safe. She is its founder, president, and spokesperson. But it still proposes you find the donations to Make Our Schools Safe will not be considered indirect gifts to her. The key consideration, again, is that she doesn't experience any personal benefit from those donations. She's been very clear the contributions are exclusively for the benefit of Make Our Schools Safe. They stay with the nonprofit. She won't be receiving any portion of them. Now, this is also not a case where she's going to benefit from the financial stability those donations might bring to Make Our Schools Safe, because like I said before, she said she doesn't collect a salary or receive any consideration at all for her work for the nonprofit. So given those unique facts, it doesn't seem like the donations made to Make Our Schools Safe fit within the concept of an indirect gift to her. Again, the rule limits that concept to situations where the public officer receives the gift or at least experiences a benefit from the gift. It doesn't seem that that's the case here, so the draft recommends you find any donations made to Make Our Schools Safe, even if they're coming from district vendors, will not be considered indirect gifts to this board member. And very briefly, the second question the opinion addresses whether Make Our Schools Safe can contract with a uniform company to sell merchandise from that uniform company on its website, when that uniform company also sells clothing to some district charter schools. The board member was wondering if that presents a conflict of interest for her. And as explained in the opinion, I don't believe that scenario appears to trigger a violation either. The only statute I could think of that might apply is section 112.313, subsection 7. That prohibits public officers from accepting employment or entering into any contracts that could compromise their public duties. I guess the argument there would be if she was employed or in contract with Make Our Schools Safe, and Make Our Schools Safe is doing business with this district vendor, arguably it might influence how she treats the vendor in her capacity as a school board member. But like I said before, that statute requires an employment or contractual relationship. Because this board member is not being paid by Make Our Schools Safe, it can't be said she's employed by it, because employment requires compensation. And also, there's no indication she has any contractual relationships with Make Our Schools Safe either. You all found that uncompensated directors of nonprofits, unless they're members of nonprofits, won't have any contractual relationships with it. So for those reasons, I don't believe section 112.313 subsection 7 is applicable here either. So I don't think she has a conflict if her nonprofit continues to sell merchandise from that uniform company on its website. I present the draft for your review, and I'm happy to answer your questions.
Any questions for Mr. Schaefer? Dr. Brown, yes.
The language there says to me, school system to do something, and a member absolutely feels that they can do something. And I believe that I really am believing this specifically doing that simply to show that they love me. But at that point, I should be very careful in terms of, I guess, the nonprofit itself. So the line really solely goes to the mind of the principal, that if she doesn't believe that it's the biggest concern, then it's not. And it strikes me as a little amorphous.
Well, maybe I can clarify it for you, Commissioner, through the chair. There's two statutes there. The first statute is section 112.313 subsection 2. That's going to prohibit a public officer or employee from accepting any donation based on an express agreement with the donor that is going to influence some public action that the public officer has to take. So she's going to be prohibited from reaching any arrangement with a district vendor that if they contribute money to her nonprofit, she's going to take some action on her behalf. So subsection 2 requires an express agreement. Subsection 4 is a little bit trickier. It's going to prohibit her from accepting any donations to herself when she knows or she should know it's being given to influence some action she might take as a school board member. I would say, though, that is a gift coming to her. You know, the gift law analysis I'm talking about here is just gifts being made not to her but to her nonprofit. And that's why I don't believe that it's going to trigger a conflict there under the gift law.
Any other questions for Mr. Schaefer?
Chair, thank you so much. And just to be clear, your opinion is fully based on the fact that there is no compensation to either her or her husband. And if that status ever changes, the opinion also obviously changes.
It's possible the opinion could change, you know, if they're contributing to the financial stability of an entity that's paying her, we would have to reanalyze the issue.
Any other questions? Do we have a motion as to the advisory opinion? Commissioner Brady has moved to approve. Is there a second?
Second.
Seconded by Commissioner Rosanko. We're open for discussion. Any discussion? Commissioner Brady.
But we do really need to understand that in the world of nonprofits, what we perceive as gifts and influence is in some regards very different than it is in the world of private companies. People do not work because they like the accolades that they get for doing great work. And there are many different ways to reward people, all of which we have to
Commissioner Berger.
Just to add to that comment about the discussion on page 6, I view that paragraph at the top of page 6 as cautionary language. That's how I read the opinion. Potential violations of the statutes. Obviously, I don't see anything in the statute that addresses the appearance of impropriety, but there is a footnote that sort of alludes to that, and combined with these sections. So I agree with you.
Any further discussion? Seeing none, we will call question. All in favor of the motion to approve the advisory opinion as drafted, please say aye. Aye. Any opposed, nay. The motion carries. All right, our next advisory opinion case is file number 2730, conflict of interest, voting conflict, city commissioners, business engaging in various pursuits, including doing business with the sheriff's office that provides law enforcement to the city. This is in Tamarack. I believe that the requester is not in attendance today. All right. All right, we're rehabilitated up here now. Okay, so Commissioner, our general counsel, I believe, has this case. Is that correct, Mr. Anderson?
Yes, Mr. Chair, thank you very much. Just briefly, there are 4 questions in this opinion. It goes to the situation involving a city commissioner. The first question is whether or not his insurance-related business can, if it's doing business with the local sheriff's office, which provides law enforcement services to his city, if that would create any conflict of interest. The draft opinion says that it would not, because the commission in many cases before has construed the statute 112.313(7)A, which has a requirement that an official have a employment or a contractual relationship with a business entity or with another government agency that is doing business with his government agency. And the commission has said that they don't believe that intergovernmental agreements like the sheriff's office agreement with the city for internal law enforcement services constitutes doing business. And so that element is absent, and therefore the draft concludes that there would be no conflict under 112.313(7)A based on the existing agreement. That's question 1. Question 2 is, what if they do a new agreement? And the answer to that is the same. It's not doing business. It's intergovernmental cooperation as construed by the commission over many years. And then the third question is, well, what if the commissioner's business was to do business with other governments within the county in which his city is located or throughout Florida? And the fact pattern on that was somewhat amorphous and not necessarily so because it's possible future business and we really don't know the context in which that would occur. So the answer to question 3 is not very definite, but rather it says, well, by analogy to the answers in questions 1 and 2, we believe you probably can understand as things materialize what your conduct should or should not be as you go forward with other governments doing business with your but it encourages the requester to get back with us in the future if they have a particular concrete situation and they're unsure about it, then we'll be glad to entertain more definitely questions at that time. And then question 4 says, well, what if the commissioner's insurance business were to partner with an existing city vendor to do business in relation to other governments? And the partnering basically means collaboration. And many times this commission has said that when a person's company holds a contractual relationship with an agency or with another business entity, that they personally don't necessarily also hold a contractual relationship. It's a sort of a buffering of the corporate entity. But the Ethics Commission has also said, though, that when the other company that's doing business with the official's company is seeking personally the services of the official in particular, particularly when it's a licensed service like insurance agent or some related occupation, that really you don't have that buffer effect there and you do have the privity between the official and the other company. So since the other company would be a vendor of the city and therefore a business entity doing business with the city, such partnering or collaboration would be prohibited by 112.313(7)(a). So in essence, we have 2 definite no conflict answers, a somewhat amorphous 3rd question that we may entertain more specific questions on in the future, and then a 4th question that says that his company and himself cannot do business with existing vendors of the city. And if you have any questions, I'll attempt to answer them. Thank you.
Any questions for Mr. Anderson? All right, seeing none, do we have a motion with respect to this advisory opinion? Commissioner Berger moves to approve. Any second?
Second.
Second by Commissioner Rosanka. Any discussion? Seeing none, all in favor, please say aye. Aye. Any opposed, nay. The motion carries. Thank you, Mr. Anderson. All right, our 3rd matter is file number 2731, Conflict of Interest, Department of Health's Citrus County Health Administrator and Health Officer serving on Board of Directors of nonprofit, providing grant to the department in Largo. The requesters are not in attendance today. Deanna Roming is providing our advisory opinion. Please proceed. Welcome, and please proceed.
Thank you, Chair. Commissioners, this opinion concerns the Department of Health, Citrus County Health Department, hereinafter referred to as DOH Citrus, and its administrator/health officer serving as a director of a nonprofit organization. The nonprofit is called Citrus County Community Charitable Foundation. The request was brought forth by the department's chief legal counsel, Ms. Beverly Deer, in behalf of the Department of Health and DOH Citrus's administrator/health officer. Ms. Deer would like to know whether a prohibited conflict of interest would be created if the department were to appoint the administrator/health officer or another highly ranked employee of DOH Citrus as a director of the nonprofit corporation. The nonprofit corporation in question awards grant money to DOH Citrus. Relevant to this inquiry is section 112.313, subsection 7A of the Code of Ethics. The first part of this section would prohibit the employee from having a contractual relationship with the nonprofit. an entity doing business with the agency by virtue of a grant agreement between DOH Citrus and the nonprofit. The second part would prohibit the employee from having a contractual relationship, which would create a continuing or frequently recurring conflict between his private interest and the performance of his public duties, or which would impede the full and faithful discharge of his public duties. This means that both prohibitions are based on the existence of a contractual relationship. Here, except for reimbursement of out-of-pocket expenses, the subject employee will not be compensated for serving as a director on the nonprofit's board. In the past, you've held that reimbursement of expenses does not constitute the compensation that would indicate a contractual relationship. You've also found that uncompensated directors of a corporation who are not also members of the corporation have no contractual relationship with the organization. Here, there is no indication that this subject employee will also be a member. Therefore, it appears that the employee has no contractual relationship with the nonprofit and as such would have no prohibited conflict under section 112.313 subsection 7A. There is another section to consider. Under section 112.313 subsection 3, a public employee is prohibited from acting in an official capacity as a purchasing agent to purchase services for his agency from a business entity of which he is a director. It also prohibits a public employee from acting in a private capacity to sell services to his own agency. However, since DOH Citrus does not purchase, rent, or lease any realty, goods, or services from the nonprofit, this subsection also doesn't apply. Therefore, under the specific circumstances presented, it does not appear that a prohibited conflict of interest would be created were the Department of Health to appoint the subject employee or another highly ranked employee to serve as an uncompensated director of the nonprofit corporation. I now present this draft for a review, and I will be happy to answer any of your questions.
All right, commissioners, do we have any questions for our attorney, Ms. Rami?
Dr. Brady Woodford.
Dr. Brady.
I'm sorry. All of these are basically public entities, irrespective of their tax status. The hospital is created as a Citrus County government nonprofit that distributes funds to other nonprofits as well created for the sole purpose of receiving money from the county and other people. I don't have a problem per se with him serving, but should we not include some language that says when you're the administrator of an agency which is seeking public money from a corporation that was created to distribute public money, that you at a minimum should not participate in the discussion or the awarding of funds to the agency that should be distributed by that?
In this, Commissioner Brady, through the chair, if I may, in this particular circumstances, I believe that there is some protection here. It doesn't necessarily deal with the code of ethics, but he would be refraining from voting, if I'm not mistaken, under their particular bylaws. So there is in the materials and page, there is some protection that addresses your concern where he would not be actually voting on those matters.
So our understanding in the rules of the nonprofit that distributes the funds, there is language that members of the board of directors agree to, that if they have any potential conflict of interest, they restrain.
That is correct. So even though there's no conflict under the code of ethics, there is something within their bylaws that addresses that.
And I mean, just so we create all these entities and give them alternative tax structures, you know, to really make them freer to do things that government can do. And we should really try and sort of implement fairly significant standards. Thank you.
Thank you, Commissioner. Thank you, Council. Any other questions? Mr. Carvajal.
Thank you, Mr. Chair. And I think I'm in the exact same place that Commissioner Brady is. Even if the bylaws of the organization suggest this, this is actually an advisory opinion to the administrator, and I would feel a little more comfortable as a reminder that at least recusing yourself on that vote or disclosing your conflict potentially on it would be wiser advice for this individual, because if he did vote on it, even if it were in conflict with the bylaws, is that, I think, where Commissioner Brady was also headed.
Does our General Counsel want to weigh in on that issue?
If I might, thank you, Mr. Chair.
Yes, sir.
On that point, if the law doesn't actually require abstention, or if the elements of the offense are not present as they don't appear to be here, then it would be, I think, improper to pronounce that he has to do certain things based on the code of ethics. And that's why I think it is important that there is a thing in the bylaws here that goes to that dynamic. I don't think that the commission really has the power statutorily to say that somebody needs to abstain from voting, or to declare that they have a conflicting employment or contractual relationship when the facts don't support that under the law. Now, occasionally we have issued an opinion where we will add a sentence or two, and this is very rare, to the effect of, even though there's no conflict under the code of ethics here, we suggest that one might seek to take a higher path or a more transparent path and refrain from certain actions. But that has been very rare that that's ever been done, and it has no real power to it. And the implementation of that in a given situation, particularly when they have their bylaws that are specific on a certain point, I think could be problematic if we were to have any language like that in the opinion. I think it's cleaner as it is drafted. It's sort of like akin to when the commission in the past used to admonish people when they didn't have any power to do it and go outside of the penalties that were provided for. And it didn't take the legislature very long to come back and put in the code of ethics that we couldn't go beyond the bounds of the power we were given, and in regard to penalties. And similarly, I think that here, I don't think we really have the ability to go outside the letter of the law, and the facts here don't indicate that letter of the law is applicable to show it. Could be something that might in the future be a proper thing for a legislative suggestion to have a little bit of, different standard enacted, but I think as the law is now, it would be cumbersome and problematic to attempt to add any sort of aspirational language to what is essentially a clean legal requirement of the law that's either there or not there.
Thank you. Any other questions? Sure, Commissioner Carvajal.
I thank you very much, Council, for the advice on that. The bylaws that you referenced aren't referenced in here. Is that material to your opinion?
It's attached to the materials. It's not referenced in the opinion itself, but they are attached. They're pretty lengthy, but let's see. It's also referenced in the letter from Ms. Deere, which is on page 8 of 46 of the materials, and the specific section. If you give me a moment, I can find it.
Well, maybe just to clarify, if they are attached to the opinion, are they part of the opinion from that point forward? Right. I see head nodding, but no verbal response. So.
If I may,
Yes,
they are
please.
not part of the opinion. They're the backup materials to the opinion.
Is this something that could be addressed with a footnote with regard to the bylaws?
Yes.
All right,
We
and
could, if I may, we could easily add a footnote that says, that includes that the bylaws reference that no vote may be taken under the circumstances described, or he cannot participate. Whatever the facts reflect, I'm not exactly sure of the particular language, but the facts reflecting the bylaw prohibition.
Mr. Chair, thank you so much. I think I accept the guidance of the council and that we should not extend beyond our area, but I think if we're going to be most fair to the person requesting our opinion, then we should lay out as much as possible to protect them as we can. So, if it's appropriate for a footnote, great. If not, maybe this public testimony is enough.
Mr. Anderson.
Through the chair, if I might, often there are footnotes, like for instance in the opinion that I had earlier, we had a footnote in there that was factually recited that the requester's business was a minority owned business, just to emphasize that fact. And here there could be a footnote that says, we note that the organization's bylaws provide, and that could be a factual thing in a footnote. It wouldn't be a gravamen or an anchor for the reading of the opinion, but it would put front and center that reality.
Let me ask a procedural question. We do not yet have a motion. Just assuming that somebody likes the footnote idea, does that constitute the commission can amend the advisory opinion here from the bench to that effect? Do we have to be so specific as to say where the footnote needs to be?
No, sir, you do not have to be that specific, and if you
Great.
feel confident that the staff can get that footnote added in the way that you are giving us direction, then you can go ahead and approve the opinion with the caveat that the footnote will be added, and it will be added before the opinion is issued next week.
Thank you for keeping me straight. All right. Any other questions for our council with respect to this advisory opinion? All right, seeing none, do we have any motion as to
Motion
the
to,
advisory opinion?
A motion to adopt the opinion with the inclusion of a footnote indicating the bylaws of the charitable foundation in the opinion.
Thank you, Commissioner Brady. Is there a second?
Second.
We have a second from Commissioner Carvajal. Any discussion? Seeing no discussion, we'll call the question. All in favor of the motion, please say aye. Aye. Any opposed, nay?
Oh, aye, sorry.
Commissioner Brady votes for his own motion.
Yes.
All right, let the record be clear. All right, motion carries. Thank you very much, council. Nice job. Thank you. I think that's your first one, if I recall. All right, so welcome to the game. Glad to have you. All right. We will proceed to file number 2732, Executive Branch Lobbying, Lobbyist Registration, the great city of Tallahassee. Our counsel, Caroline Clanky, I think, is up. Oh, I'm sorry. Is our requester here? You know, you got to watch the chair every moment. Welcome. Glad to have you. So we'll note the appearance of our requester. Thank you.
Caroline Clanky, Commission staff. File number 2732 arose from an inquiry from a lobbyist registered to lobby the executive branch. In her inquiry, the requester, who we noted for the record is here with us today, queried as to whether the registration process requires the identification and disclosure of certain third-party entities that help facilitate the retention of lobbyists. Such administrators, she explains, do not themselves engage in any lobbying activities, nor do they direct any of the policy aspects of lobbying on behalf of the principal. Rather, these intermediary entities facilitate the retention of lobbyists on behalf of corporate principals and assist in the administrative and regulatory compliance of lobbying. Section 112.3215, subsection 3 is the statutory provision requiring the registration of lobbyists who lobby the executive branch of Florida government. Pursuant to the requirements of this process set forth in the statute, the lobbyist must provide certain information identifying themselves and register the principal for whom they will engage in lobbying activities. Thereafter, the principal is then required to provide a statement attesting that the lobbyist registrant is authorized to represent the principal and identifying the principal's main area of business. Thus, the lobbyist registration system is designed to provide clarity and transparency regarding the identities of individuals that employ lobbyists, i.e. principals, as well as the identity and interests of those individuals that engage for compensation in activities that are defined as lobbying, i.e. lobbyists. Section 112.3215 does not contemplate or require the identification or disclosure of third-party administrators or facilitators that aid in the administrative aspects of these activities, but do not themselves meet the definition of either a principal or a lobbyist. As such, the opinion before you provides that the administrator of a contract formed between a lobbyist and a principal is not required to be identified as a principal for the purpose of lobbyist registration. However, the opinion goes on to state that if, during the registration process, the principal correctly and accurately identified itself, and once identified, the lobbyist seeks for clarity to further identify and disclose the third-party administrator whom is a signatory to the contract with the requisite lobbyist. Neither the statute nor the rule would prohibit such additional information to be provided. We also, in conjunction with, as we've had a lot of conversations about lobbyist registration, the final paragraph of the opinion also encourages lobbyists and principals to retain records that are required by law in the statute that outline all of these relationships between third-party administrator functionaries. This opinion is submitted for your consideration, and staff, as well as the requester, are available to answer any questions you may have.
Do we have any questions for Ms. Clanky? Commissioner Bray?
Does it matter that the third party is also registered as a lobbyist?
The third-party administrator is not registered as a lobbyist.
But if the third party administrator was registered as a lobbyist and gained a incredible set of expertise in terms of helping handle the administrative and regulatory functions of a lobbyist and entered into agreement with them not to lobby, but to assist in those other activities, does that make a difference?
It theoretically would. Those are very disparate from the facts before us here, though, because in the instant case, it is very clear from the facts and the representations of the requester that the third-party administrators do not engage in any activities that constitute lobbying. They don't seek to influence engender the goodwill of an executive branch agency official, for example, nor do they seek to influence the policy decision-making of an agency official. Rather, they help with compensation reporting and lobbyist, regulatory compliance requirements, things of that ilk.
Any other questions from Ms. Clanky? All right, our requester is here today. That is Cynthia Henderson. Ms. Henderson, you are welcome to speak to the commission if you wish to make any comments about your request. All right. Any questions for our requester? They let you off the hook. No questions. All right. Very good. Any other questions? Yes.
Mr. Chair, I just want to acknowledge that I know the requester through prior professional relationship.
All right. Thank you very much, Commissioner Lesnoff. Any other questions, Commission, or do I have a motion?
Motion to approve the advisory opinion as written.
Thank you. We have a motion from Commissioner Rosanka. Is there a second?
Second.
Second from Commissioner Carvajal. Any discussion? Seeing none, all in favor of the advisory opinion as drafted, please say aye.
Aye.
Any opposed, nay. The motion carries. Again, Ms. Henderson, thank you. We appreciate your participation in this process and making this proactive inquiry of our commission. That's what we need folks to do. And so thank you for doing that, and thanks for being here today, and congratulations. Got what you wanted. All right. We will proceed to consideration of financial disclosure appeals, item number 9. Item 9 on the agenda consists of the appeals of automatic fines under the financial disclosure law. There is one appeal in which the appellant has asked to be heard. We will take that one up first, then we will consider the other appeals. The appeal for which a hearing has been requested is appeal number FD 2017-129, Stephen Mayers. Is Mr. Mayers or counsel present? All right, thank you, Ms. Fulford. He is not present, so I would ask, do you need to hear from our staff counsel, Mr. Lane Johnson, on the matter, or is there a motion?
It was actually waived, so I don't think he's going to request, dispute the outcome.
Right.
Move to adopt the order as presented.
Second.
I have a motion and a second to adopt the order on the hearing as presented. All in favor, or any questions, excuse me, or discussion? Seeing none, all in favor, please say aye. Aye. Any opposed, nay? Thank you very much. Okay, and now we will take up or is there any of the other matters for which a hearing was not requested that any commissioner wishes to handle individually? Lobo, Giles, Carmona, or Harris? Seeing none, do we have a motion with respect to those matters?
Motion to adopt those matters unless as recommended.
We have a motion to adopt. Any second?
Second.
Second by Commissioner Rosanka. Discussion? Seeing none, all in favor, please say aye. Aye. Any opposed? No opposed. Motion carries. Thank you very much. All right, the next item, number 10 on today's public agenda, is consideration of the 2008 annual report. This is the report that is sent to the House and the Senate. It is also made available to the public from our website, and of course to you as members. Do any members have any questions or comments, or is there a motion to approve?
I just have a question, as maybe a question
Sure.
for the chair. How does this Florida Commission relate to other commissions in size and monetary expenditures in the country? I mean, I know the report says we're a leader in the Commission on Ethics realm, but is there such a comparison?
You know, that's such a great question for the chair, and in citing my outstanding delegation abilities, I'm going to delegate the response to that to our executive director. Yes, ma'am.
I'm sure that that's compiled because the Council of State Legislatures puts together lots of information like that. I don't know the answer. I would say we're probably larger than quite a lot, not as large as some. Also, it's not always apples to apples because some places combine ethics and elections. Some places only have, for example, offices of legislative ethics. They don't have a thing that applies to executive branch. But Florida has always been pretty substantial. I think there are some places, you know, some of the bigger states, California, New York, Chicago has a very active ethics board. Ohio has an extremely active ethics commission. So I would say we're probably, we're up there. We might not be number one, but I would say we're up in the top 25%.
I didn't know if you got any of that information, because I know you go to the
I do, but I haven't, if that information's been compiled in those meetings, I haven't noticed it, but I do know that Hawaii has a very big ethics board, and very strong participation in the Council on Governmental Ethics laws. And then you have places like Rhode Island, there's some places that only have 1 or 2 people, so.
Thank you.
All right, so we'll chalk the chair up there as not knowing the answer to the question either. Just so that we, of course, you would sort of think that the vice chair would know what the answer to the question was before she even asked. But I guess not everybody can be prepared today. So anyway, are there any other questions? And I will duck when I ask that. Any other questions or any other comments on the annual report? All right, seeing none, do we have a motion to approve the annual report?
So moved.
Commissioner Rosanka moves to approve the annual report. Commissioner Brady has seconded it. Any discussion? All in favor of approval of the annual report, please say aye. Aye. Any opposed, nay. It carries. Okay, item 11 is a sad item for us today. We have a former commissioner who has passed away recently. Ivan Marty Ford was a member of our commission a number of years ago, and Ms. Doss, we will again ask you to say a few words about Mr. Ford.
Mr. Chair, thank you for giving me the opportunity to speak about Commissioner Ford. He served on the commission from 2010 to 2015, so I don't think any of you had the opportunity to meet them and to meet him, and I'm very sorry for that because you would have really enjoyed knowing him and working with him. I think he is the first member to pass away who was serving since I've been executive director. So for that reason, and just because of how much I liked Commissioner Ford, I really felt like I wanted to say something about him. His background with the FBI and on the Board of Bar Examiners made him a great addition to the commission, but what really made Commissioner Ford special was how down-to-earth he was and how humble. He had seen and done so much in his life. Of course, a lot of his stories he couldn't tell us, or else he'd have to kill us. But he was always more interested in hearing what the other person had been doing lately and was up to than in telling his own stories. One of our former chairs described him, after hearing of his death, as a prince of a man, and I'd say that sums it up. Commissioner Ford was just a great guy. When he left, he gave me a pin that I've never worn until today because I didn't think I earned it. It is one of his FBI retired lapel pins, and so I'm wearing it today in his honor. I always carry it in my briefcase. I believe that Marty's family, including Bev, his wife of 56 years, are watching our live stream today, and to them, I just want to say how sorry we are, and thank you for sharing him with us. We will never forget him, and members, thank you for your indulgence, I appreciate it.
Well, thank you. Thank you. We appreciate that. It is, I think that this commission is great service to our state, and we certainly appreciate those who have come before us to participate in that role and done so honorably with great integrity. So our condolences certainly to the Ford family. So thank you, our Executive Director, Ms. Doss. Speaking of which, our Executive Director is anticipating, it's very hard to believe in looking at her, but it is anticipating retirement here at the end of June. And it is our right and our responsibility as the Commission on Ethics to select her successor. I think that each of you have received a memo that is part of the materials for today, in which the Executive Director has made a recommendation. that our Deputy Executive Director and General Counsel, Chris Anderson, be promoted by the commission to the position of Executive Director to be effective upon Executive Director Doss's retirement. So is there any comment or motion and such with respect to that? Commissioner Berger.
Based upon the report and my experience here, serving on this board, I would like to make the motion to appoint Deputy Executive Director / our General Counsel, Chris Anderson, as the next Executive Director with a salary to be negotiated with the chair.
We have a motion. Is there a second?
I'll second that motion.
We have a second from Commissioner Brady.
I have a question.
We have a question from Commissioner Rosenka. Yes.
What would happen to the general counsel position?
My predecessor retained the general counsel position, and if, in this case, my conversations with Mr. Anderson is that if he's selected, he'll retain the general counsel position as well. So he'll be executive director / general counsel, just like he's deputy BD / general counsel now.
Because I would hate to lose that.
Any other questions or discussion of the pending motion? Commissioner Metz.
I would just comment that Chris is highly trained. He started out as an assistant state attorney in the second circuit. Great wisdom on my part. I'm real pleased to see him.
Commissioner Berger.
I just want to make the comment that his knowledge, being here, and his loyalty, it was an honor to make that motion.
Thank you. Any other commentary? Commissioner Carvajal.
Just to express due diligence, while I'm new to the commission, I have had a number of conversations already with the general counsel in his capacity, and I feel comfortable with the recommendation as presented, and I think his leadership will be accepted. Thank you very much, Executive Director Doss, for presenting that.
Any other commentary or discussion of the pending motion? Commissioner Richter.
Good luck.
Any other discussion?
And I move that the chair simply record a unanimous vote on the part of the motion to hire. Cast a unanimous vote on the motion to hire.
Piling on the pending motion, so I think we got to take a vote and make sure it's unanimous, Mr. Anderson, with all due respect. So let's do that. I think, well, I'm going to take that as calling the question. Is there any, excuse me, all in favor of the motion, please say aye. Aye. Any opposed, nay? Well, Mr. Anderson, congratulations. We'll let you say a few words. Try to keep it under 45 minutes. If you want.
Thank you for the opportunity to comment briefly, and thank you all very much for this opportunity. I want to thank Ms. Doss for her recommendation and all of her service. And I really appreciate it, and I'll strive to continue to do my best for the commission. And I'm really proud to work here. It's an important function, and it's good to see all of you from so many walks of life and so many backgrounds participating. It's not just 8 or 9 computers up here, it's human beings from all over the state making it real. And thank you so much. I really appreciate it. Thank you very much.
Well, we sure look forward to working with you in that capacity as well. Now, we're not running the existing executive director off anytime soon. We still have a ways to go. With regard to that, I'm going to take a little moment of chair privilege. I guess we'll consider this part of my chair report and comments. But I think that it is and will be fitting to for our chair, our commission, to honor our executive director as she heads off to the great beyond of retirement. One of the highlights of being on the commission is that annually in July, we have a dinner where all the members of the staff attend, and so it's just a nice evening where we all get together and get to know each other a little better, break bread, et cetera, and it's a good time. I would like to see if our staff can't work out perhaps moving that meeting or dinner that we have from the July time that we normally do it, which would be past our executive director's retirement passing, and maybe move it up a month into June to utilize that as an opportunity to honor her and her great service to our commission. And I would also like, if it's possible, that all the former members of our commission be invited to attend that. So I guess I'm going to put that out there as a charge. I'll work with our deputies. The executive director gets nothing in the way of say with respect to this. Well, she'd say whatever she wants, but we'll ignore it dutifully. And so I will appoint myself, I guess, to work with staff to see if we can make that happen, find the right type of facility for it. Just in case someone from the governor's office or the legislature's watching, we all pay our own way, so don't sweat that. And I think we ought to have a good time and enjoy that and do it while our beloved executive director is still in the employ of the commission. So hopefully you won't object too much to that, and we sure will enjoy doing that.
Thank you very much. How hard will you be expecting me to work the next day at the commission meeting is my only question.
We would expect your normal level of outstanding integrity and outstanding service, and I'm sure that there won't be quite enough wine to go to your head on that issue. Not worried about that at all. So, Madam Executive Director, that concludes my report. Do we have any report from the Executive Director for the good of our commission?
Only two additions. We have another appeal in our litigation section. The Villanueva case from last commission meeting, which was an informal hearing. Mr. Villanueva has now appealed. Deanna Ramming and Melody Hadley will be handling that. And I'm very proud to announce that our very own Carrie Stillman, Stand Up, has been appointed to the program committee of the Council on Governmental Ethics Laws, which was something the commission, I think in our last meeting or the one before that, said we should be more involved in, and now we certainly are. And she's going to be establishing the program and has a hard job because the last conference was really excellent. But she's up to it.
Great. Anything else in our Executive Director's report?
No, thank you.
All right. Well, unless there's an
Chair, just a question. There had been a discussion about possibly moving the April meeting. Do we have to make any public notice of that here, or is that automatically worked?
It's all right. It's automatically worked. It's already noticed on our website, and the complaint coordinator has contacted the council who frequently appear before us. Nobody had actually been noticed to appear at that meeting yet, so it's all straightened out.
Right, and so just turns out that one was scheduled on Good Friday, so we thought perhaps it would be a good idea to move it off of that date. So, so it has been done and will be properly advertised. Any other comments for the good of the order today, or may we adjourn the public session? We have motion to adjourn, so adjourn.